Good afternoon, everybody. I'm your host, the Supreme Litigant, and I'd like to welcome everybody back to SmartLoad TV. If you haven't already, please go ahead and subscribe to my YouTube channel, hit that like button, and turn that notification bell on. I'll give y'all a second to do that. All right, I'm going to jump right into this. Today, I just wanted to give you a little preview of the ebook for the U.S. District Court for the District of Columbia. The ebook is not finished yet. I will finish it probably, if everything goes as planned, I could probably finish it later this week or um, um, within the next 2 weeks. All right. But as you're watching this video, um, if you can think of anything that this ebook is missing, comment it below. And if I feel like that we need to add it to the book, then I'll add it to the book. So right now I'm just showing y'all some stuff. This is not finished, so of course you're going to see some errors in it. You may see some misspelled words or something like that. But this is just a rough draft. All right, so let's go. Just want to go down. Some of this stuff has to be a little bit more. Of this stuff has to be edited, but I just want to show y'all how it's looking so far. Right here, these are all of the statutes that are required to be alleged in the complaint. When you're suing for your rights being violated in federal court, these are the statutes that you have to allege in the complaint. Let's see. Also, you'll see a lot of footnotes in here. Always read the footnotes. Always do that. And always do your own independent research. Do not just rely on me. Do your own independent research, because sometimes they do change. They overrule cases from time to time, or they repeal statutes and so on and so forth like that. The proper venue for citizens of the District of Columbia to file their lawsuits, right here. So, let me go back up. I'm gonna show y'all something. This right here. This right here, this code right here is how you find the appropriate U.S. District Court to file your lawsuit in. So let me show you what I'm talking about. So you would go here, type that in, right here, District Courts. All right, so if you are in Alabama, you would type this, you would tap on that, and it's going to tell you how many U.S. District Courts there are. And if you're associated with, let's say, Colbert County, then you're going to file your lawsuit in the Northern District Court. In other words, you're going to file your lawsuit in the U.S. District Court for the Northern District of Alabama. If you're in Colbert, Falcon, or Lauderdale, let's go back. If you are in Colorado, you would tap this. I mean, in California, you would tap this, and you would find yours at 28 U.S. Code Section 84, and it's going to divide it all. It does the same thing on every for every so-called state. That's what it does. So I put that in the book for y'all too, and I'll do something else that'll make it a little more easier for y'all, so you won't have to go through all of this. Where we at? Right here. All right, let's get back to the ebook. All right. Chapter 1, just simple stuff like that. Simple. Listen, man, make sure y'all read these footnotes. These footnotes are extremely important, in my opinion. So if you're gonna purchase the ebook, make sure you read the footnotes. Now let's go down. This chapter 2. This particular right here, you're gonna see this in almost all of the ebooks right here. You're gonna see this in all the ebooks, because y'all need to understand what probable cause is and how to determine probable cause. You need to understand the 3 types of police-citizen encounters. whether that be a full scale arrest, they call it a Terry stop, or a consensual encounter. There's three. You need to understand all of those. So I'm going to put that in every ebook because y'all need to understand that. Right here, these are all of the cases that I cite in support of my argument. Let's see. End of chapter 2. Okay, we're gonna go down a little bit more. Okay, so there's some stuff in here I gotta fix. I've done some research, y'all. So it took me some time. To be honest with you, it was giving me a headache to do all of this stuff. But I need people to understand this stuff because I can't do it by myself. So for example, if you're in the District of Columbia and you didn't know this, to be honest with you, I didn't even know this, but in the District of Columbia, there are 2 statutes of limitations for personal injuries. And it just explains. I didn't even know that, to be honest with you. But if you read this, it's going to explain it to you. And the footnotes, go and read the cases. Make sure y'all read the entire cases of each of these cases when you get time to. All right, because you're going to learn a lot just simply by reading cases. Let's see. Mostly this is going to be the same because I think this is very important, so I'm going to leave this in the book. Let's see what we got here. There is some stuff that I added in this particular book that is not in the first ebook. There is also some stuff that is in my first ebook that is not in this book because, as I've stated, the so-called law changes. So I just didn't feel like that it was necessary, or in other words, that it needed to be in this book. So I didn't put it in here. I did add this in here. This is not in the original book. When it says learn how to plead your case or you may lose, this is very important. Very important. I say important. I mean it's very important. Sorry about that, y'all. Some of these cases you'll see in here that I actually posted these in the community section on my YouTube page. The order of the complaint, right here, subsection C. And this is how the complaint is supposed to go: jurisdiction and venue, then the parties, then the ultimate facts, then the cause of actions, and then your prayer for relief. And that's it. That's the end of chapter 3. Chapter 4, answer or shotgun pleadings. I went in a little bit more on this one to just kind of explain it to y'all. But based off the research that I've done, there is no U.S. Court of Appeals that explains shotgun pleadings as thorough as the 11th Circuit. So you will only see me in this particular section. I'm going to cite cases from the 11th Circuit. And also I want to let y'all know that the other circuits, the other U.S. Court of Appeals, they also cite some of these 11th Circuit opinions in regards to when they are dealing with shotgun pleadings in their particular jurisdiction. Let's see. All of this stuff right here, you need to read all of that. All of that's highlighted in bold, make sure you read that because that is going to explain to you why you should not file a shotgun pleading. This does not just apply to you because attorneys do this stuff too, just to let y'all know. They will literally and knowingly file a shotgun pleading. They will do it numerous times. As a matter of fact, I think I have a case in here right here. It says, see also, I can't even pronounce that name. But anyway, this case right here that I cited, it involves attorneys that knowingly filed numerous shotgun pleadings, and they got sanctioned for doing that. So make sure y'all read that case too. But let me just keep scrolling through. I don't want to make the book too long to the extent to where it would discourage you from reading it, and learning about it. So I'm gonna keep it as short as I possibly can. Right now, it looks like it's about 30 some pages. I don't think it's that long though. Some of this stuff I'm gonna take out. Anyway, I'm just scrolling through y'all, so y'all don't have to listen to it. You can just pause the video and just read this stuff or something like that. But I'm trying to make this very easy for y'all. Very easy. I'm doing the research, all right, which is the hard part. It's extremely exhausting. So anyway, that'll be the end of the ebook right there. And then I also added into the ebook, like, let's say that you want to, you want a motion for leave of court so that you can amend your complaint. You want to change your complaint. I've added that motion in here. This motion is not in the first ebook. I've added a couple motions in here. What else we got? A motion for an extension of time. If you need more time to respond, I've added you a motion for an extension of time in here as well, just to show you how it looks. You have to come up with your own grounds. And in order for you to get your motions granted, you need to read cases that explain. Let me see. How should I put it? You need to read cases that explain to you how to properly ask for a motion. Ask for an enlargement of time. So no, but the only thing that you're doing is you're just stating reasons why, that you need more time. But if I were you, I would just read cases. Just read cases that elaborate on Rule 6B1 of the Federal Rules of Civil Procedure, because under Rule 6B1, that they talk about extensions of time. But the cases, they're going to elucidate a more thorough explanation, and they're going to explain it better. That's why you always need to read cases. Let's see what else I got in here. A motion to strike. If you want to strike their affirmative defenses, or if you want to strike their answer to your complaint, you can do that. However, I know what motion I got to add in here now. I got to add a motion for a more definite statement. That's a motion that I'm missing, so I got to add that one in here, because if you draft your complaint really good and they can't answer it 9 times out of 10, you're probably gonna get a shotgun pleading disguised as an answer. And when they do that, the appropriate method, the appropriate rule that you need to do, the appropriate motion that you need to file is a Rule 12E motion for a more definite statement. In other words, you want them to make their claims in their answer more clear. And in other words, you want them to substantiate it. All right. Because they will do that. I'm telling you right now, they will do it. They've done it to me. That's why I filed a motion to strike in my case. I didn't even file a motion for a more definite statement in my case. But that will be the next motion that I add in here. I forgot to add it. Sorry about that. And also I have cases in here, right here. Make sure you read these cases. Read all of these cases in here. When you get time and you purchase the book, read all of these cases. Find them and read them. Motion for summary judgment. These are just blanket motions. All right, these are just samples. All right, this motion right here, motion for summary judgment, is extremely long to do. The reason it is long to do is because you are asking the judge to forego your jury trial. You're asking the judge to rule on your case without the jury. And in order for the judge to do that, you have to point to all of the facts in the record that you got after discovery. And you have to cite case law in support of the facts to guide the court, so-called court anyway, to guide the court to rule in your favor. All right, so you're going to have to do a lot of research when you're drafting this motion, and you're going to have to do a lot of typing when you're drafting this motion for summary judgment. This is by far one of the longest motions, if not the longest motion. And I've never done one before, but I just know how long it is, and I don't even want to do it. I just don't want to do it. But if that one, what else we got? I think it might be something else. All right, and just objections. So if you're objecting to something, all of this stuff is simple, y'all. It's all simple. See how all of this stuff pretty much looks alike? It looks just alike. This is all you're doing, y'all. So if you're in another U.S. district court and you would just simply change this caption, that's really it. That's all you're doing now. That's it. Let's see what else we got. Let me elaborate on this right here. Like when you are drafting your objections, objections are governed by the federal rules of evidence. All right. So when you're drafting your objections, let's say you're saying that something is irrelevant, then the relevance typically starts at rule 401 and 402. Any evidence that is irrelevant is inadmissible as a matter of law. So if you come across some evidence and you believe that, let me rephrase that. If the defendants if they're trying to get evidence admitted into the record, and you reasonably believe that this evidence is irrelevant, then you file an objection pursuant to Rule 402 of the Federal Rules of Evidence because it's irrelevant, and you have to substantiate your objection. You can't just make blanket boilerplate conclusory objections. You have to substantiate it. How is it irrelevant? All right, that's what you got to do. But they will do that. They will issue boilerplate blanket conclusory objections. All right, they will do that. I'm telling you right now. The attorney in my case, when I sued the police, he did that over and over and over and over. That's what they'll do, y'all. What else we got? And I've just started right now. I've started drafting a sample of the complaint. All right. This complaint is not going to be long. I'm gonna try to keep it to a cause of action that's not going to take me long to do, something like excessive force or something like that. So once I finish, I'll let everybody know. But essentially, right now, this is how the ebook is looking. Once it's finished, I'm going to add a cover page to it. I don't have a cover page yet. But once it's finished, I'll add a cover page, and then I'll post links to where you can go and purchase the ebook. Hopefully, this kind of helps y'all out. And I think this is going to make this very easier, if that makes sense. That's probably not even a word, but I think this is going to make this more easier for y'all to understand. Anyway, that will be the end of this video. The Supreme Litigant is out. Peace.